A very good afternoon to all of you. We would like to continue with our discussion of terms of contracts. And as we started the last time, we are discussing exemption clauses or exclusion clauses or limitation clauses this afternoon. We have already explained that it may happen that in making a contract, one party may insert a clause contract so that when he or she is in breach of the contract, either he cannot be held liable at all, in which case there's what they call the total exclusion. That is exclusion clause or exemption clause, properly so. On the other hand, the party may insert saying that, well, when I am in breach, I can be held liable, but I cannot be held liable beyond a stated limit, maybe in terms of payment of money. Well, I cannot be held liable beyond a certain amount of money. And that way, we call it limitation clause, because the person has not fully stated that I don't want to be held liable at all. All that he or she is saying is that when I am in breach, you cannot hold me liable beyond this limit, beyond this amount of money, and so on and so forth. Now, if you look at it, an argument to be made that, yes, that should not be a problem at all, because after all, this is about contract. And there is what they call the freedom of contract. So what is the big deal? If, what is the big deal? Someone has inserted something in the contract trying to either exclude or limit liability. So on that, I would like to just quote an excerpt from Jilpo. Just a minute, and then we come back. So the point, for example, will be made that, well, contract is a contract, and because contract is a contract, the parties are at liberty to negotiate whatever that they want. So if they have, if exemption, exclusion clause or limitation clause has been included in it, why not? Why? What should be the worry of anyone? Now, what is happening is that if you look at exemption clause or exclusion clause, or even like limitation, despite the fact that it appears to be an exercise of freedom of contract as it were, no doubt, on the face of it, it also appears unfair. What do you mean by saying that unfair? To start with, on it, with two parties entering your contract, for one party to say that, well, when I am in breach, I cannot be held liable. And if I can be held liable at all, not be. On the other hand, when you are in breach, I am going to come after you. And whatever in law I can get against you, I'm going. That certainly is problematic. And as we noted last semester, when we are discussing some of the general introductory matters to law of contracts, we did acknowledge that despite the fact that if we look at the 19th century, the literature, of course, following Adam Smith work, inquiry into the causes of the wealth of nations, the laissez-faire political economy and all that. The assumption was that contract was based upon the party autonomy, that is freedom of the parties. Nevertheless, in the course of time, we have seen how the courts, lawmakers, for good reason, could not, for example, just hold their hand and say that people are free to do it at all, as whether it is fair or not fair. So we have seen how the courts and lawmakers have intervened. And for that matter, in talking about uh, exemption clause or limitation clause, it is one area where we see very much intervention of the courts, obviously to try and protect the vulnerable or the weaker party. And so what kind of protection, what kind of control mechanism do the courts place so as to ensure that the vulnerable, the weaker party, is not overexploited by the party having the superior bargaining power? Well, two things or two strategies are actually made use of. First and foremost, before exemption clause, exclusion clause, or limitation clause will be upheld as valid, it must satisfy the test incorporation. In other words, it must be shown that the exemption clause or the exclusion clause was made part of the contract and not just something outside the contract. If it's part of the contract, then it's part of the terms of the contract, and that is fine. Then that is not enough. If it is part of the contract, part of the terms of the contract, because exemption clause, limitation clause certainly appear to be unfair or unjust. In the event of a breach, the party who is seeking to take advantage of it, and obviously it will be like the party in breach. He is trying to make use of the exclusion or the limitation clause so as to either completely avoid being made accountable or minimize how far he or can be made accountable for the breach. Now, when it happens that way, the court will need to interpret the wording exemption clause to ensure that the exemption clause as worded reflects the breach which has occurred. The events which constitute the breach, which is being complained of by the innocent party, must be covered by the wording of the exemption clause. If it is not covered by the wording of the exemption clause, then the defaulting party cannot take advantage of it so as to provide defense for him, or so as to allow him to get off the hook, to escape liability. So two things, the exemption clause or limitation clause must have been incorporated, that is, must have been made part of the contract. That is one. And that is not enough. When a breach has occurred, it must be shown that the exemption clause, as worded, actually covers or encapsulates. It actually fits, coincide with the breach which has occurred. That way, it can provide protection for the party at whose instance it was included. And later, you notice when we are discussing interpretation that when the court is trying to interpret as whether the exemption clause actually covers a particular breach or event which has occurred or not, we will come across the principle that the courts are extremely strict. The courts are extremely strict when it comes to interpretation of exemption clause. And the reason for the strictness of the court simply lies in the fact that exemption clause, as I've told you, is really unfair and harsh contractual practice. And that is why the court will try to hold it to highest standards of, propriety before you can take advantage of it. So we are going to take these tests one after the other. So first and foremost, let's say a few words about the fact that the exemption clause must satisfy the requirement of incorporation. As we have said, for exemption clause to be valid, or exclusion clause to be valid, it must have been incorporated in the contract. It must have been incorporated in the contract. And when you say it must have been incorporated in the contract, that is simply to say that as a matter of fact, it must be an integral part of the contract. It should form part of the terms of the contract, the content of the contract. And a very good case to illustrate this is the well-known case of a Chapelton against the Barry UDC, which is known by every student of law of contract in the common law world. And that case, I think I've told you previously before that what happened was that we had like the city council, equivalent of maybe the district assembly or the metropolitan assemblies that we have. And they were in charge of a beach in the community. So the council had chairs, which holiday makers or those who wanted to relax by the beach side could actually hire. Now, the chairs had been packed, and on this particular occasion, what happened was the chairs had been packed, and they had just written the price that yes, this chairs for high, and that you have to take a ticket before you can actually get it. Now, when you get the tickets, at the back of the tickets, or like, I mean, on the ticket, there are writings to the effect that the council will not be held liable for any accident or damage arising from the hire of the chair. In other words, if you hire the chair, you sat on it, it collapsed, and you got injured, you could not actually hold the council liable for that. So these words were written on the ticket. So our friend Chapelton hired the chair, followed the instruction spelled out by Barry Urban, that is Barry UDC. And unfortunately for him, the chair collapsed. And when the chair collapsed, he sustained injury, and he got his lawyers and sued the Barry Urban District Council. Now, when the council was sued, the council put up that, well, they are not necessarily disputing the fact that the plaintiff might have sat on the chair, collapsed, and sustained injury. Nevertheless, they are very much aware of the fact that on the ticket, which was given the plaintiff, there are words, there are inscription on it to the effect that the company, I mean, that is the council, will accept liability for any injury or damage, however it arises. So that was the defense that they were trying to put up. Now, eventually, the excuse me, the trial court, the county court in Barry seemed to have agreed with the council that yes, despite the fact that what happened was an accident resulting in the injury. Clearly, the council was exculpated. The council could not be blamed because the words were quite clear on the taking that the council was prepared to accept liability for any injury. So that was the holding of the county court. The plaintiff was definitely aggrieved and he appealed the matter to the next level of the judiciary. And when the matter came before the appellate court, the court held that the tickets on which there was supposedly the exemption clause, which the council is supposed to take advantage of. The ticket was a mere voucher or receipt for the money paid for the hire of the chair. And for that matter, the conditions or the wordings which have been written on it could not be considered as forming part of the contract. Because mind you, you get the tickets after you have paid for the chairs. So you are giving like the ticket that yes, you have, but the court was trying to say that if you look at the way and manner things were organized, you could actually, of course, they'll say that, okay, if you look at the PAL, where the PAL was, the notice was there saying that, yes, there are, the chair is for, I think, a 2 dime per chair. That is what was written. But the notice did not include like the words that if you take the chairs for 2 dime, then the council is not prepared to accept any liability. The purported limitation or the exclusion clause was actually written on the ticket. Yeah, so that was it. So the takeaway was that the court came to conclusion that the exemption clause could not be considered as forming part of the contract because the plaintiff got to know about it after the contract and not during the contract. Yeah, so that is the point, that for exemption clause to be upheld as valid, it must be incorporated in the contract. And being incorporated in the contract means that it must have been brought to the attention of the party either before or at the time of the contract and after. So this brings us to the very important question that in which ways may the requirement of incorporation be satisfied? In other words, how can we prove that the exemption or the exclusion clause has actually been made part and parcel of the contract? Well, if we look at the case law and the literature, this may be done in one of 3 main ways, as it were. By signature, by notice, or by course of dealing. So let's take this one after the other and say a few words about them. So incorporation by signature, that is, we are dealing with signed documents where the exemption clause is contained in a signed document. Then the position of the law is that in absence of fraud or misrepresentation, a person who has signed a document is deemed or considered to have agreed to what the document is saying. So that is why we have to be careful. When you put your signature on a document, you have to note that it means that you have accepted to be bound by it. And a very good case, which you ought to read, is the case of a Lestrange against Gracop. Now, in the case of Lestrange against Gracop Limited, the plaintiff bought cigarette vending machine, and she was given a document to sign, although they were in smaller characters, but they could still be read. She signed without really reading. And when she got the cigarette vending machine installed in her cafe, in no time, it proved to be defective, not functioning well. So she sought to actually sue the seller. And the company which sold it placed reliance on an exemption clause in the document that the buyer had signed. And the buyer sought to say that, well, I didn't know that I was going to be bound in this way, and the seller could not be held liable. Now, Lord Justice Scranton, who was part of the panel who decided was a Gracop Limited in the English Court of Appeal, made the point that, quote, the plaintiff, having put a signature to the document and not having been induced or included to do so by any fraud or misrepresentation, cannot be heard to say that she's not bound by the terms of the document because she has not read them, unquote. So his lordship was saying that you not having signed, you not having read the document is not important. What is important is that you signed, and then when you signed, nobody defrauded you, nobody tricked you, or nobody deceived you into signing, or nobody subjected you to duress or any other improper pressure for you to sign. So far as you have signed, whether you read it or not doesn't matter. So you are bound by what the document says. So that is the point about Lestrange against the Gracop. And of course, we have noted already in the case of a Wilson and Broby, when we're discussing the early part of terms of contract, especially the parole evidence, where the court, among other things, noted that mere negligence in not reading a document is not excuse from the effect of the document that you have signed. Now, that is just the general rule. So to this general rule, we certainly have a respectable exception. And one exception is that where the person signed the document as a result of fraud or misrepresentation, that is to say, you were deceived into signing the document. If that is the case, then the mere fact that your signature is on the document will not mean that you are bound by what the document is saying. And a very good case to illustrate that is the well-known case of Curtis against Chemical Cleaning Company Limited, where a woman took her wedding gown to the laundry, and the wedding gown had certain decorations, beads and sequins. Now, when she gave the gown to the laundry, the attendant gave her a document to sign, and she inquired from the attendant if, like, what the purpose of that document was. And the attendant told her that, well, by the document that she was signing, the company was saying that it was not prepared to actually accept liability for distraction to the bis and the sequence. That was what the attendant told the woman, so she signed. Meanwhile, the rare effect was that the company was not prepared under any circumstances to accept any liability at all for any disruption to the dress. Now, later on, when the woman came to collect the dress, it was badly stained. Right. So she sued the laundry company, and then the laundry company sought to place reliance on the so-called exemption clause, which the woman had signed. And the court held that, well, the laundry or the cleaners were not protected by the exemption clause, because the true extent or the true scope of the clause had been misrepresented to the woman, because the woman had actually inquired at the time of signing that, please, this thing that I am signing, what is the purpose? Then you tell her that, well, we are saying that should anything happen to the bis and sequence, then the company could not be held liable. So that was the understanding with which the woman signed. But the company really meant more than that. It meant, in fact, that should there be any disruption at all, we are not going to be held liable. And the court said that, well, insofar as the true scope or effect of the exemption clause had been misrepresented to the woman, her signature on it could not actually make her liable or could not bind her to what the document was saying. So you see how Curtis against Chemical Cleaning Company Limited is an exception to the case of Lestrange against Graco Limited. Of course, related to that is play. The same thing, another way of putting that exception is the play we call the non-S factum. So non-S factum. So the woman was trying to say that, yes, I have signed the document, but the document I have signed is of different character or nature from what I intended to sign. A document I intended to sign was a document which says that I am assuming risk for any disruption which may happen to the bis and the sequence, and not certainly saying that I agree with the company that should there be any disruption, I'm not going to be held liable. So the plea of non-S factum is another way of saying that despite the fact that my signature is on the document, I should not be held bound by the document because it is not my act. It is not my true act. It's not my true act in the sense that I did not intend to actually sign a document of such a nature. Let us keep that in mind. And that was why the interesting case of Sanders against Angular Building Society, otherwise reported as Galley and Lee. An old lady was persuaded by her nephew to sign a document conveying her house to her nephew's friend. Now, the old lady had believed that she was signing a deed of gift to her nephew. Now, she had not read the document because her glasses were broken. Yes, although it was held that the document was valid, but the court made some useful points that the signed document, before you can be excluded from the signed document, must be fundamentally different in effect from what it was thought to be. So if you can show that the document that you sign is of a fundamentally different character from what you thought you were signing, then you can plead the plea of non-est factum. non-est factum, and that actually available. And secondly, before you can also rely on non-est factum so as to escape from a signed document, you must prove that you are not negligent in signing the document. You're not negligent in signing the document, because if you look at the uh, the woman who signed the document, the deed of gift against Angular Building Society, you notice that there was negligence. What was the negligence? You know very well, as I am sitting here, my glasses are broken. So I have to find time and go and get a replacement. Of course, I don't know as to whether that will apply to me, but on a more serious note, the woman's glasses were not there, meaning that her ability to read was impaired, and yet she went ahead and signed. So that was a negligence. So if it had not been for that negligence, then non-est factum could have been successful, so as to release her from the document that she signed. Yeah, there are a plethora of cases concerning non-est factum. You can look at the case of Nkrumah against Sewa, the case of Wilson and Brobe, and then a Kwame against the Score, where it also emphasized that the mere negligence in not reading or signing is not the basis for invoking non-est factum. Now, so we have seen how the exemption or exclusion clause can be said to have been incorporated by means of signature, so that where the party against whom it is being invoked sign the document, as we have seen, the exemption clause can be taken as having been incorporated in the contract. That is fine. What about situation where the person has not put a signature? So we want to look at incorporation by notice. In other words, where the exemption clause does not require signing, does not require signature, then the position of the law is that you must have been given reasonable and sufficient notice of the existence of the clause. In other words, you must have been made sufficiently aware that the exemption clause was actually meant to be part of the contract. If that was the case, then the exemption clause can actually be treated as forming part of the terms contract. So let us keep that in mind. And a very good case to illustrate the point that where the exemption clause does not require signature, then adequate notice must be given to the other party before or during the time of making the contract. The well-known case of Parker against Southeastern Railway. Parker against Southeastern Railway, very interesting case, decided in 1877. What happened in Parker against Southeastern Railway? Well, the plaintiff in that case deposited a bag in the cloakroom at the railway station. If you go to the railway station, they have like a place that you can leave, like maybe your stuff there. And he was given a ticket, and the ticket with the number, on it, which he was given, had a date and words at the back. And the words were that on the front of the ticket, it was written, see back. So the ticket, you have like the ticket is written here, see back, meaning that look at the back of the ticket for certain writings. So that is what happened. And what was written at the back? if you look at the things written at the back, among other things, it was stated that, quote, the company will not be responsible for any package exceeding the value of £10. In other words, it had been written at the back of the ticket that if you leave your stuff in the cloakroom and anything should go wrong, you cannot let the company pay more than £10. Meaning that if the value of what you are putting in the cloakroom exceeds £10, then you have to actually make sure that you don't put it there, because it's a risk that you are taking. If anything go wrong, the maximum compensation you can get is just £10. So that was what was written at the back of the ticket. Now, the plaintiff in this case did not really read the ticket. Of course, not only Parker, a good number of us, we don't like reading, especially when we buy it. We don't even get time to, or we don't bother to read the user manual. We just start using it. Maybe it's a behavior we need to check so that we start reading before we start making avoidable mistake. So Parker did not read the ticket, and Parker's bag was worth £24, a little over that. It got lost, and when it got lost, Parker decided to sue the railway company. And when the railway company was sued, it placed reliance on the words at the back of the ticket. And the words at the back of the ticket, of course, was not an exemption or exclusion clause, it was a limitation clause. Limitation clause in the sense that the company was saying that, well, if it will be held liable for any breach or any missing item at all, not more than what? £10. But in this particular case, the missing item was more than £24. So at the trial, it was a jury trial in those days. That is the judge sitting with the lawyer to help him to decide the questions of facts. So the jury is a trial of fact, and the judge will give like the legal direction. So the judge directed the jury to consider whether the plaintiff had read or was aware of the special condition on the ticket upon which the bag had been deposited. Now, the jury answered in the negative. That is to say that the jury said that, well, having regard to the circumstances, the plaintiff was not aware that the bag that he deposited with the company, it was governed by the condition that if anything went wrong, the company could not be held liable for more than £10, as it were. So that was the verdict of the jury. And on basis of that, the trial court entered judgment in favor of the plaintiff. Now, the railway company appealed. They appealed the decision. And when it got to the English Court of Appeal, the English Court of Appeal came to the conclusion that the direction which the trial judge gave to the jury was wrong direction, had not directed properly on the questions that they needed to investigate and answer. And in the view of the Court of Appeal, the important question which needed to be asked for the jury to answer was whether the defendant had done what was reasonably sufficient to give the plaintiff notice of the condition. In other words, whether the defendant had made the plaintiff aware that the exemption clause existed. if he had made the plaintiff aware that the exemption clause, the defendant could take advantage of the exemption clause. So that was the crux of the matter. And of course, the court directed that there should be retrial. Retrial means that the Court of Appeal did not answer the question as whether the exemption clause in this particular case was valid or not. But all that it said was that the court below, that the trial court, had not asked the relevant question for the jury to answer. So there was a need for the matter to be remitted back to the trial court for retrial, or what the lawyers will call trial. So based upon the question that the Court of Appeal thought ought to have been asked in the court below, the Court of Appeal was saying that if the plaintiff, that is Mr. Parker, was aware of the conditions at the back ticket, then he'll be bound. On the other hand, if he did not know, he will still be bound if he was given the ticket in such a way as amounted to reasonable notice. In other words, what was crucial was that, having regard to the circumstances, could it be said that reasonable notice, enough information, had been given to the plaintiff regarding those words which amounted to the exemption clause? And on that note, it is instructive to quote the dictum of Lord Justice Mellish. Lord Justice Mellish rendered himself as follows: I am of opinion, therefore, that the proper direction to leave to the jury in these cases, that if the person receiving the ticket did not see or know that there was any writing on the ticket, he is not bound by the conditions. That if he knew there was writing and knew or that the writing contained conditions, then he's bound by the conditions. That if he knew there was writing ticket, but did not know or believe that the writing contained conditions, nevertheless will be bound if the delivering of the ticket to him in such a manner that he could see there was writing upon it was, in opinion of the jury, reasonable notice that the writing contained conditions, unquote. So ultimately, it comes back to what they call like objective test, or the position of the reasonable person. Would an official bystander, for example, consider the circumstances as being adequate so as to let the other party be aware that those words actually existed and they were meant to form part of the contract which was being concluded? So that was the crux of the matter. So the emphasis is on reasonable notice, not actual notice. And that is what the case of Thompson against Landing came to add, that the notice we are talking about, we are not talking about actual notice. Of course, if there's an actual notice, then that makes it very easy. But it is reasonable notice. It makes it objective rather than subjective test. Because if it's actual notice, then it becomes subjective. A person will say, I didn't know, or I didn't see it. But if we say it's a reasonable notice, then it is a matter of what? Objective test. So let's pay attention to that. And that is why I would like you to contrast the case of Thompson with the case of Taunton, shoe lay packing, because the facts are very similar, but the courts came to different conclusions. So if we look at the Thompson against the London, Midland, and Scottish Railway, for example, in that case, the ticket indicated that the conditions of the contract could be seen at the state office. That is what the ticket stated, that yes, if you wanted to know conditions of the contract, go to the station master's office or look at the timetable. Now, the exemption clause was in clause 55 timetable. And if you pay a little bit of money, maybe a pence, you will get a copy of the timetable so that you read it. And the ticket itself only costs 2 and 6 pence. So in the given those circumstances, it was held by the court that reasonable notice had been given. And as I indicated, the test is objective and is not subjective. For that matter, it is quite irrelevant if the affected party is blind or illiterate or otherwise unable to understand it. Of course, that also seems harsh. And if you look at the more recent legislation, for example, if you look at what they call like the disability, if you look at the persons with the disability act, for example, you will notice that the courts will reason differently now, when the court will have to, for example, decide whether enough had been done to bring an exemption clause to the attention of to attention of what do you call it, a person who is blind or a person who has a hearing problem. And the hearing problem here, especially when you go to our lorry stations, Asafo and Kejetia or Circle, sometimes they have a recorded message and they are making some announcement, and that can also be a way of giving notice about certain exemptions. So where a person is, for example, suffering from hearing impairment, deaf, how do you expect that person to actually know about the existence of the exemption clause, which you are saying by word of mouth? Yeah, so as I said, these cases are actually old cases, but if you look at our 2006, like the Persons with Disability Act, 2006 Act 715, certain protection has been given to person who suffer from various disability, and for that matter, it be different how the court may have to interpret some of these things, especially so where the contract involves a person suffering from some of these disability. And as I said, if you take cases like Thompson against London, Midland, Scottish, this was 1930 case, and in those days, person with disability right had not properly been recognized. And as I told you, in Ghana, 2006, we have the Persons with Disability Act at 715, and it gives various protection to a person with disability. And that is why I think that some of these rules may probably have to be recalibrated or reinterpreted when we are dealing with a contract involving person with disabilities. So, I mean, that was just for your information. Of course, if you look at the the English case of a Jia against a Kujawa, like a notice containing the exemption clause was stuck on the windscreen of a car. It said that, well, passengers travel at their own risk. Just imagine going to a lorry station and there's a notice boldly on the car that, well, passengers travel on their own at their own risk. We'll go and such a car. But that was the situation in Jia and Kujawo, and notice was in English. And the passenger concerned here was a German passenger who could not speak English. Now, during the trial, ultimately the court held that he was not bound by the clause because being someone who could not speak English, reasonable care had not been to bring it to his attention. So if you look at it, this actually is a departure from the Thompson case, which we have just seen. And if that is so, if you go to hotels, if you go to restaurants or other public places in which they have those writings, you park your car at your own risk or valuable left in the car and so on and so forth. So question is, what about illiterates? Well, the argument will be that so far as English is an official language, it is no thanks to you if you cannot read and speak English language. And if you are going to engage in certain transaction, you have to make a decision as to whether you really want. Nobody has asked you to go to a hotel or go to a restaurant. And for that matter, if you go, of course, we also have a law of thought. You do it later on. There's something we call the occupier's liability. So the owner of the premises has got a responsibility to alert visitors or those who are coming into the premises about all hidden dangers. But quite apart from that, he doesn't have any such obligation. Yeah, so that is something that we may just have to think about. And as we speak now, the Law Reform Commission is trying to conduct a study as whether we can have our own unfair contract terms and legislation in which we make provision for some of these matters. Now, in the course of this course, I will make available to you a document from the Law Reform Commission to the faculty, which the Dean referred to us to look at it as our input. But having said that, it bears emphasis that part of the responsibility of giving adequate notice about the existence of exemption or limitation clause is that attention must be drawn to any unusual clause. In other words, where the exemption clause is not something which is quite usual, something which can be taken for granted, and people don't even have to, if you like, think a lot about it, then the responsibility in terms of what you need to do to bring it to the attention of the other party is actually high. So therefore, the more unusual the exemption clause, the greater the responsibility to bring it to the attention of the other party. And that was why in the case of Thornton against shoe lane parking, it was stated that a person who drives his car into a car park might expect to find in his contract a clause excluding liability for loss or damage to the car. But special notice should have been given of a clause purporting to exclude liability for personal injury. In other words, if I park my car, if I go to a car park and there's even a disclaimer notice over there, I can reasonably take it for granted that the management or whoever is in charge of that car park is simply telling me that should there be any loss or should there be any injury to the vehicle that I have parked over there, I am not going to, just 1 minute. Yeah, so a lot will have to be done to bring the unusual clause to the attention of the person. As I said, if I park my car, I can reasonably take it for granted that the owner of the premises is saying that, well, if something should happen to the car or something is lost and so on, he or she is not going to accept responsibility. That is fine. On the other hand, I did not expect that the person will say that he cannot guarantee my personal safety, and that if anything should happen to my person, he or she is not prepared to accept responsibility. If that were the case, that is something unusual. Unusual in the sense that we don't often see such, such a disclaimer or such exemption clause being. And that is why taunting against shoe lane parking is saying that if the exemption clause you are trying to include in the code is more unusual, is more uncommon, then you need to do more, bring it to the attention of the other party. And on that note, I would like to also remind you of the interesting case of Inter Photo Picture Library against the Staloto Visual Programs, a 1989 decision of the English Court of Appeal, which reinforces the point which earlier on be alluded to in the taunting shoe lane parking case. And if you look at the Inter Photo Picture Library Limited against Staloto Visual Program, the plaintiff ran a photographic transparency lending library, and the defendants were advertisers. So there was a telephone conversation between them. And as a result of that, the plaintiff delivered to the defendants 47 transparencies together with the printed note containing 9 printed conditions. Now, one of the conditions, called condition number 2, provided that the transparencies were to be returned within 14 days, failing which a holding fee of £5 a day and VAT will be charged. After 4 weeks, the transparencies had not been returned, whereupon plaintiffs sent an invoice to the defendants for £3,783.50 as a holding charge for the transparencies. Now, when the matter came before the court considered the issue of whether condition number 2 was sufficiently brought to the attention or notice of the defendant so as to make it a term of the contract. And the court concluded that no, it had not been brought sufficiently to the attention of the sufficiently to the attention of the other party. And for that matter, it was not considered a term of a contract. And the Court of Appeal made the point that the more unusual the clause, the greater the notice required. And again, where the exemption clause does not require signature of the party, notice of that term must be communicated to the other party before or at the time the contract is made and not after. And of course, taunting against the shoe lane makes that point. And it's a very interesting case in terms of like the facts. it's just like maybe, let me say, Kumasi, we don't have like I'm not aware of a car park in Kumasi, which is the equivalent of the car park at the Kozuka International Airport. Probably the new airport they are doing in Kumasi may have that. But yeah, where you enter the car park, there's a machine there, you put a coin in, or this time they have like what you call you press it, and then a token will come out. So very similar arrangement happened in the Taunton, again, the Shoe Lane Parking Limited. So the plaintiff in this case made the contract to the car company, inserted a coin in the ticket machine, and the ticket was issued afterwards. And conditions were displayed inside the car park. So if you enter the car park, you have a lot of conditions in terms of what the company will accept and what the company will not accept and all that. So, but the fact of the matter is that you don't become aware until you have entered the car park. And because you don't become aware until you've entered the car park, the court was the view that the notice of it brought to the attention before or at the time of making the contract. That is the point. Just like the Chapter and Barry you do see. Over there to us, we notice the notice of the exemption clause came after the contract. It should be before or at the time, or put differently, the notice must be contemporaneous with the contract. In other words, the notice of the existence of the exemption or the limitation clause should be given at the same time that the contract is being made, as happened in the case of Ole against Marlborough Court Limited, a very interesting case, especially for those of you who like using hotels when you travel. In Ole and Marlborough Court Limited decided in 1949, we had like a husband and wife, like a couple. They visited the hotel as guests, and as is usually the case, you get to the hotel, you go to the reception, and then you are set up, you pay, you are shown your room. So they were allocated their bedroom, and they saw later on one of the walls of the bedroom a notice stating, quote, proprietors will not hold themselves responsible for articles lost or stolen unless handed over to the managers for safe custody, unquote. I mean, this is quite common in the various hotels. So all valuables should be handed over. I mean, that is what we usually see. So a similar thing happened in Ole. Now, eventually, the wife closed the self-locking door of the bedroom, went downstairs, and hung the key on the board in the reception room. And while she was away, the key was wrongfully taken by a third party who opened the bedroom door and stole her first, some of her valuables, and they sued the hotel. And when the matter came to court, the court held that, because like the hotel put up the argument that is why we warn you that you should have handed over your valuables to us. We didn't do that, so you're not going to be held liable. And so the court needed to decide the walls on the walls of the hotel room, can they be considered as forming part of the contract which was made between the couple and the hotel? So what needed to be decided was that at what point was the contract made? And the court took the view that the contract was made at the point that they were being given the room, that is the reception point. And since at that time, they had not been told or they had not been given any notice that the exemption clause written on the walls existed, it could not be treated as forming part of the contract. And for that matter, the notice was considered as having been given after the contract and did not form part of the contract. So